So, good evening, everybody. I hope you can hear me loud and clear, and we're going to deal with a potential defendant, Oliver, in question 3. So, everybody hear me? Yes, okay, very good. All right, yeah. Okay, thanks very much for that. So in tutorial 3, we're obviously doing theft, fraud, and theft-related offences, and I do realise that we've fallen behind in the lectures, so that's why I've asked Dorothy if we could have an extra lecture on Friday, the 22nd of January, to catch up a little bit. Normally by tutorial 4 we're sort of out of sync, but not normally by tutorial 3, so I'm sorry about that. I seem to be going a bit slowly on the earlier section, which I don't normally do. So here, treat this as like a demonstration question, and what I propose to do is set an additional question to go through on the 30th of January, the Saturday afternoon lecture. So then you should have covered all the material, and maybe you'll have a better idea of what to do. So don't worry if we don't sort of understand everything at this point in time. What I've done in the slides is to put in a few extra slides with the definitions and diagrams and things. So hopefully it will be a little clearer and a bit more sort of demonstrationary. Okay, so as with most problem solving, we're going to go through this chronology in a chronological format and follow the narrative. In paragraph 1, we see that Oliver is obviously this professional pickpocket, and in paragraph 1, he picks on 2 victims. Now, the first victim doesn't look very promising, the woman victim, because the pocket is empty, and in textbooks you see reference to, you know, whether any crime is committed if someone picks an empty pocket. And so this is this scenario, and the answer is no, because there's nothing to steal. But this would give us quite a good sort of vehicle for explaining the basic definitions of theft, and then say, well, okay, we're not going anywhere with this, but you know, we can define theft and say why it's not going anywhere. So that will be picking the empty pocket there. So considerations of theft. So if Oliver is charged with theft, which section number would apply? So he's charged with theft contrary to which section number of the Theft Act 1968? Which section number is the definition section of the Theft Act 1968? Okay, yeah, section 1.1, very good. Okay, and then there are sections 2 to 6 which sort of elaborate on the 5 elements of theft: dishonest appropriation, property belonging to another, intention to permanently deprive. So dishonesty would be section 2, appropriation section 3, property section 4, belonging to another section 5, and intention to permanently deprive section 6. So section 7 is the penalty section. So, you know, this gives the sentencing maxima in terms of, you know, years imprisonment. So what is the sentencing maxima for theft in England and Wales? How many years? mean, people don't normally get the maximum, but 7 years, good. So, so that's section 7, 7 years. Don't get confused with 10 years, because in Hong Kong, that theft under the theft ordinance is 10 years, and also it used to be 10 years in England and Wales, but it's been modified. So that's seems to be a common mistake that's made here, so quite understandably, really, because people sometimes have some experience of Hong Kong law. Okay, so the second victim in the first paragraph is the man, and here this is a bit more promising because there's something to steal. There's the wallet containing the £100 cash, etc. So we need to go through that, go through the elements. Has there been appropriation, property belonging to another? Cash, for example, can that constitute property within the meaning of the Theft Act 1968? Well, yes. If we looked at the wording of Section 4, we would see that there is specific reference to money, meaning notes and coins, in the Theft Act 1968. Okay, so that will be theft, but because Oliver pushes the man away, there's the application of force and the stealing. We also need to consider robbery. It doesn't look like a likely robbery, and it might be the lower end of the scale, but still technically it could be a robbery. So we'll need to look at that as well. So in the second paragraph, Oliver, delighted with this, he goes to meet his friend in the bar, Andy, and he orders a round of drinks. And this is perhaps slightly peculiar. So the drinks cost £5, and he pays with a £10 note. So obviously he should get £5 back. But the barman makes a mistake and mistakenly hands back £15, which means that Oliver got £10 too much. So it's the excess money that's the subject matter that we need to consider. So could Oliver be liable for the retaining of the excess money, the £10? Could that constitute theft? So we'll see what the situation is there. Now, in this question, unfortunately, there's this paragraph, this part of it, where Andy offers Oliver a mobile phone very cheaply at a gross undervalue. Now, here, the sort of legal point is whether the mobile phone is sort of stolen, and is he engaging in handling stolen goods. Now, that's not currently being examined on our syllabus. We used to do that, but we're not being examined this year on handling, and that's been the situation for a number of years now. So I will mention the handling and attempting to handle the stolen goods, depending on whether the prosecution can prove the phone was stolen or not. But don't worry about that too much, because it's just a mention point, because you're not going to be examined on that particular point, so it will be a mention point. Then moving forward to the third paragraph, Oliver takes the tram to get home, but he doesn't pay for the tram ticket. Now, we're not told the sort of payment system for this particular tram ride, and it just looking as if you got a ticket before you board the tram, but of course we can't be sure about that, so maybe it's you pay on exit, but it looks like he doesn't pay for a ticket before he gets on the tram. So here we need to sort of think about obtaining services dishonestly, which is an offence under the Fraud Act 2006, and maybe making off without payment, depending on the payment system for the tram ride. So obtaining the service, the tram ride, and so it's not goods or anything, it's a service, dishonestly. So he doesn't pay for the ticket. But maybe we need to look at that concept of dishonesty and look to see whether there could be a counter argument on the part of the defendant to say that he thought he was acting honestly. And then the final incident, so we're going through all these sort of sub-incidents in the chronology of the answer, and Oliver is on his way home. He stops off at the supermarket to buy food, and the groceries are checked out by the checkout assistants, but she misses a few items, or he misses a few items. Oliver pays the bill, but at that stage he has no realization that he's been undercharged. It's only later that he discovers this, and he thinks he's been lucky and goes home. So there we need to ask ourselves whether there could be theft of the unpaid for, or unbilled, if you like, grocery items. So this part is important, so look out for this in the question. What offences contrary to the Theft and Fraud Acts have been committed? So here, when there was mention of attempting to commit a crime, then technically that offence is contrary to Section 1.1 of the Criminal Attempts Act 1981. So it's not, strictly speaking, within the scope of the question. So but I think probably, that they wanted you to just mention it. So in the exam, if you say, well, we could think about attempting to commit a certain crime, but looking at the scope of the question, the Theft Act or Fraud Acts, this doesn't appear to come within the scope, because anybody charged with attempted offence would be charged with Section 1.1 of the Criminal Attempts Act 1981. Okay, so as we go through it, as our normal approach would be, break the question down into the smaller parts and follow the chronology of it as I did then, and break it down into sub-scenarios and what the sort of conclusions or sub-conclusions are for these scenarios. And then at the end, it's best to give some sort of global overview of what we've determined in the answer. So these are the offences that we would be considering. So we'll focus on theft. We'll mention attempted theft because technically I don't think it, strictly speaking, comes within the scope of the question. Robbery, handling, it comes within the scope of the question, but you're not going to be examined on that. Obtaining services dishonestly, this is an offence under the Fraud Act 2006, not to be confused with obtaining services by deception, which was under the old Theft Act 1978, Section 1, but that has been abolished by the Fraud Act 2006. And then this sort of theft-related offence, making off without payment, which is not too difficult to understand. It's a very discrete, limited offence, and we can go through the requirements for that. Okay, so initially, the first scenario is not very promising. So there could be theft and or robbery, that neither of those offences is viable. So we will, however, define theft and see why we're not going to get anywhere in terms of mugging the woman. And so, yeah, we should, as soon as we introduce the possibility of theft, the concept of theft, we need to define it. So section 1.1, I should perhaps put section 1.1 there. Dishonest appropriation of property belonging to another with intention to permanently deprive the other of it. So I put this diagram in so that we understand a little bit better the components of theft. So we can use this first victim as, you know, a way of introducing a lot of legal points and issues which we're going to, you know, going to crop up repeatedly throughout the answer. So the theft is broken down into the actus reus and the mens rea. So firstly, we've got to look at actus reus. No actus reus, no crime. So appropriation, assuming the rights of an owner. So section 3 helps us a little bit with that. Is there any assumption of any rights of the owner? You know, it's a, well, no, there isn't, because there's no property there. There's no possession of any property. Certainly no property belonging to another. So we've got no actus reus as far as the woman is concerned. So we don't actually need to go any further and consider dishonesty and intention to permanently deprive the other of it. So appropriation, taking to oneself, now it would be any removal of any property from, you know, the woman's person, but of course she doesn't have any property. So okay, if she did have some property and there was an assumption that a right of an owner, namely, say, possession, then we might proceed to the other elements, and dishonesty and intention to permanently deprive the other of the property. But there does seem to be a major problem here. So what is the problem? Well, Oliver doesn't actually take anything. The pocket is empty, picking the empty pocket scenario. So no appropriation, no property within meaning of section 4 of the Theft Act 1968, no belonging to another, and no actus reus of theft. So in other words, no crime. Now, if we don't have any sort of actus reus, then we don't even need to think about the mens rea. But one point that would be worth mentioning here is that the wording of the question seems to suggest that Oliver, in any event, would have what we call conditional intent. So here, Oliver only has the intention of stealing anything worth stealing. And here there is authority that this so-called conditional intention, intention to steal anything worth stealing, is not sufficient mens rea for theft. However, as we will see later, conditional intention is sufficient mens rea for attempted crimes, and also for burglary, say burglary with intent. And the authority that we might have for this is Esom. So this here, conditional intention, this is not really part of the answer, but I think it's good to explain exactly what this concept is so everybody gets it right. So conditional intention is where the defendant explores an item to see whether it would be worth stealing and is detained or decides not to do anything further. So, for example, there might be some sort of conditional intention on my part when I want to go and burgle someone's flat. Now, I don't necessarily know what's inside the flat. Does the flat owner have a collection of bow ties or something? Or has that collection of bow ties that I've read about, has it been sold? So the defendant explores an item to see whether it's worth stealing or would do inside the premises. And even though in theft, conditional intention is insufficient mens rea, as far as attempted offences and also burglary with intent, conditional intention has been held to be sufficient. So in Esom, this illustrates this point. Esom picked up a lady's handbag belonging to a fellow cinema goer in the cinema. He was sitting next to this lady and she had the handbag on the floor, and he rummaged around through the handbag, but he only found lipstick and tissues. Now the handbag actually belonged to another cinema goer who was an undercover policewoman, and the handbag was attached by a thread to the policewoman's wrist, or her little finger or whatever. So there was a thread between her and the handbag. Now maybe here the defendant would have picked out goods like money or something like that, but he wasn't interested in the tissues and the handbag, so he didn't find anything of value. So he was charged with theft, but there was no specific property, and he argued that all he had was conditional intention. He would only sort of select items that were worth stealing, and it was held in this case that conditional intention was insufficient mens rea for theft. So Oliver doesn't look as if he can be guilty of theft in this particular circumstance, so you could mention that he's potentially liable for attempted theft. And the other possibility would be robbery, but there doesn't look like many indication of that. And for robbery to be established, we would need to establish first of all a prerequisite that there was theft, and then in addition to the theft component, that there would be the use of force, or trying to use force, or trying to frighten people, so putting or seeking to put any person in fear of then and there being subjected to force. So Section 8 then, robbery refers to stealing, and if there's a problem with theft, then we can't have a robbery, and that's exactly the situation we have here. So could we have an alternative offence like attempting to commit a crime? Well, yes, we could, and Oliver could be charged with attempted theft pursuant to the Criminal Attempts Act 1981. Because it looks like he's carried out acts which are more than merely preparatory to the the commission of the main offence, in this case to steal. But the major point here is looking at the instructions in the question. it appears that there would be offences under the Theft and Fraud Acts the answer is limited to offences under the Theft and Fraud Acts. And if we're looking at attempted offences, then Section 1 of the Criminal Attempts Act 1981 doesn't fall within the scope. However, I would say it's worth just very briefly mentioning in a sentence or so, about the possibility of attempts. Okay, so here, if we look at the second potential victim where we think there might be a more viable offence, so where Oliver pushes the man during the course of stealing, potentially this could be robbery, and it would be contrary to which section? Okay, so we mentioned robbery previously, and we said that robbery would be charged contrary to Section 8 of the Theft Act 1968. So remember, with theft, the definitional section is Section 1. Dishonesty to intention to permanently deprive, those 5 elements, that's Sections 2 to 6. Section 7 is the penalty section, and Section 8 is the next offence along, which is robbery, so Section 8. So looking at robbery itself, we can see in the diagram that there needs to be stealing as a prerequisite of property belonging to another, and immediately before or at the same time as the stealing, the appropriation of the property belonging to another, and in order to steal. So the robbery is limited in scope to use of force or seeking or putting or seeking to put someone in fear of force being used. It's limited to the time immediately before at the time of stealing, and in order to do so. And it's got to be in order to steal. So it uses force on any person, or putting or seeking to put any person in fear of then and there being subjected to force. So that's the actus reus. We would always consider that first, and then we would look at dishonesty, intention, and mens rea. So both intentions, intention to appropriate the property and intention to permanently deprive the owner of the property. Okay, so the elements of theft are a prerequisite. If there is a difficulty establishing the prerequisite, then we're going to have a problem with the robbery. Okay, so the actual wording of Section 8. So a person is guilty of robbery if he steals, and the steals means theft in terms of Section 1.1 of the Theft Act 1968. And then immediately before, at the time of doing so, and in order to do so, he uses force. So one option is he actually uses force. So there's stealing and there's the actual use of force. Or in the alternative, he puts or seeks to put any person in fear. So one is like, use of force, a battery. The other is, assault-based, if you like. So trying to put someone in fear of then and there being subject to force. It doesn't matter that that isn't successful and the victim isn't actually scared, but putting or seeking to put someone in fear of then and there being subjected to force. So as far as the man is concerned, there's a pushing, yeah, so we'll deal with that in a moment. But Oliver steals, it looks like he steals £100 in cash, the wallet and the credit cards. Now, okay, he throws away the wallet and the credit cards, but that doesn't mean that he doesn't intend to permanently deprive the owner of it. If he throws them away somewhere where the victim won't find them, not easily anyway, then we can apply section 6.1. So appropriating the cash, so this is the actus reus, so appropriation of cash or wallet, credit cards belonging to another, so the cash would belong to the man, the wallet would belong to the man. Actually, the credit cards would belong to the credit card company. It probably says on the back that the credit card issuing company retain ownership in the credit card. So we have to remember all these things when we're drafting a charge or an indictment. So yeah, in throwing away the items, does he intend to permanently deprive the owner of the property? So is that appropriation? He assumes the right of an owner. The assumption of the right of an owner, it can just be one right of an owner. It doesn't have to be all of them. So possession, for example, is the right of an owner. So he's in possession of the cash, the credit card. So the cash can be, property within the meaning of Section 4 of the Theft Act 1968, because that mentions money. The wallet is tangible property, and the credit cards are bits of plastic. They can be viewed in that way. Of course, things like checks, etc., they can be viewed as bits of paper, but they also can be viewed as bits of paper that have special qualities, and they represent some sort of shows in action, or thing in action, legal right in action. Okay, so he might be dishonest, but what about intending to permanently deprive the owner of the property here? So here, if Oliver treats the items as his own to dispose of, regardless of the owner's rights, then case law seems to suggest that the courts will deem intention to permanently deprive the owner of the property. And one key case to understand here is the case of DPP and Lavender. So DPP, Director of Public Prosecutions, against the defendant Lavender. So in this case, the defendant, he lived in a public housing unit with his girlfriend. She was the tenancy holder, and the girlfriend was not very pleased because she had these sort of rotten doors on her public housing unit, and she had noticed that down the road there was another public housing unit which was empty, and that her public housing unit had lovely doors. So she persuaded the boyfriend to get the good doors from the empty house and put them on her house, and get the rotten doors from her house and put them on the empty public housing unit. So this is like an unauthorized rearrangement of the council's public housing property. So the defendant was arrested by the police, and he pleaded not guilty, that he had not intended to permanently deprive the public housing authority of their property. In fact, they still had the property. It was just on a different house down the road. But it was held in this case that Lavender had treated the doors, the items, as his own to dispose of, regardless of the owner's rights. So this was quite a broad brush approach treating any sort of dealing with the property, not strictly speaking getting rid of the property. So that seemed to be accepted. Now, DPP and Lavender is not great sort of decision precedent-wise because it's a divisional court of the Queen's Bench division case. But this approach was approved of in the case of Marshall, Erin and Coombs a bit later. That was a Court of Appeal decision. So DPP and Lavender there, a very useful case, but if you cite that case, because it's fairly easy to remember, you do need to say it was approved of in Marshall, Erin and Coombs, or the case of Marshall. If you just call it Marshall, that's fine. Okay, so only mention the sort of straightforward points and then focus on the more contentious points. So what about dishonesty here? So it looks like Oliver is dishonest. So when we're thinking about the element of dishonesty, we should first think Section 2 of the Theft Act 1968. First of all, is there any argument under Section 21A, 21B, 21C? So 21A as an honest belief in a sort of claim of right, and 21B is an honest belief that the owner would have consented to the appropriation had the owner known of the circumstances of the appropriation. And then 21C, an honest belief that the true owner can't be found by taking reasonable steps. Okay, so if any of those honest beliefs is present, then the statutory provision says that the defendant will be deemed to be honest. So 21A, honest belief in a claim of right, no, that wouldn't apply here. 21B, honest belief that the owner would have consented has a known of the circumstances of the appropriation, no, that doesn't apply here either, and certainly the last one doesn't either, where honest belief that the true owner couldn't be found by taking reasonable steps, when it's quite clear here that none of those apply. So you wouldn't label this point, you just say it was clearly that none of the paragraphs can be argued under Section 2, and in the absence of an argument under Section 2(1), A, B or C, then we have to apply the sort of default common law test, and at the moment this would be Ivey and Genting casinos. So here the test is, we look at what Oliver does, his state of mind, his belief, and whether he honestly believes these things, so that we look at the circumstances, if you like, as the defendant believed them to be, and then we ask the question, was the defendant's conduct dishonest by the standards of ordinary decent people, bearing in mind the view of the defendant. So taking that context, that standpoint, was his conduct dishonest according to the standards of ordinary decent people? So this is the new test in Ivey and Genting casinos. So we'll come back to Ivey a little bit later, but just maybe I'll introduce the facts here. I don't think we would repeat the facts here in the answer, but just this is a really important case and you should look at it in your case book. And I don't know if anyone's heard of the defendant. Oh, he wasn't. He was the claimant in this case, actually, Phil Ivey. So he's quite a famous poker player. So the unusual thing about this case is that it's actually a civil case, a contract case. And the situation was that this gambler, a professional gambler, Phil Ivey, he was the sort of Tiger Woods of the poker world, and he's got his, if you Google him, he's got his own YouTube channel and makes lots of money out of that, and he gives people tips about, you know, how to improve their gambling skills. And he had gone to the Genting casinos in Mayfair in London, and he had played a baccarat type game called Punto Banco, and he had won 7.7 million pounds from this game, and he employed a technique that's been described, or was described in the case, as an edge sorting technique. And this is where the gambler tries to ensure that the same deck of cards is used you know, throughout the games, and he can exploit irregularities on the printed backs of the cards, because this guy's got a tremendous memory. So all the sort of irregularities, you know, he after the croupier has sort of dealt the cards a number of times, he can remember them all. So this greatly increases his chances of winning. Now, Phil Ivey, he considered this, you know, a form of legitimate gamesmanship, but unfortunately the casino thought otherwise, and when they saw that he had won and realized how he had done it, because he was perfectly open about this, you know, it was sort of announced on his YouTube channel or whatever. So then the casino withheld his winnings. So Phil Ivey took the casino to court and claimed the 7.7 million pounds. But the argument before the court by the casino was that, you know, this edge sorting technique was essentially a form of cheating within Section 42 of the Gambling Act 2005. And so, if it was a form of cheating under Section 42 of the Gambling Act, then it was in breach of an implied term of the contract between the parties, that, you know, to play or gamble without cheating. And the case went all the way to the Supreme Court, and Ivey was found to have cheated within the meaning of Section 42, and so the claimant couldn't claim his winnings. And one of the things that the court had to consider was whether Phil Ivey was dishonest, and if so, you know, he wouldn't be able to claim the winnings. Now, it's in civil law and in contract law, the definition for dishonesty has not been the same as in criminal law, and the Supreme Court thought that this was wrong, and they stated, even though they were dealing with a civil case, that in criminal law the criminal courts should actually follow the civil law test, and this is essentially the civil law test. So, you know, what was the defendant's actual state of mind or belief at the time of the alleged dishonest behavior, you know, and did the defendant hold those beliefs genuinely, honestly? And secondly, the key question, you know, was, bearing in mind that context or those circumstances which are sort of you know, determined from the defendant's subjective point of view. The second question is, you know, an objective question. Was the defendant's conduct dishonest by the standards of ordinary decent people? Okay, so Ivey and Genting casinos, very important. So even though technically, in terms of precedent, it looked like the statements about the criminal law test of dishonesty, that they were obiter. This has been accepted by the courts, and now we're expected to follow the Ivey and Genting casinos test of dishonesty. So in other words, the same test for dishonesty as in civil law. Okay, so as part of the actus reus, we've already determined that we should have had the elements of theft. That was part of the robbery actus reus. Then we have to focus on the sort of, I suppose, aggravating feature of robbery, the use of force, or putting or seeking to put someone in fear of then and there being subject to force. So here there's pushing, so there's no real problem that there is the actual use of force, and but is this enough force? Well, the case law suggests that even minor amounts of force, any force will do. But of course, the timing of the use of force is important. It needs to be used at the time of stealing. So in this particular scenario, there is no problem with uses force on a person immediately before at the time of stealing. But there's a further requirement that is important, not problematic in this particular scenario, but in order to steal, okay? And that is quite a significant limitation on the scope of robbery. So here, Shendley is the authority for this. We don't really need to know much more about Shendley. So here the victim forced the shopkeeper to give him a receipt after he'd already stolen the goods in order to effect his escape. So the force was used after the theft in any event, and it was used not in order to steal, but in order to effect escape. So Shendley, the defendant, was not guilty of robbery. And then overall in robbery, dishonestly, the various intentions, intentional force, intention to permanently deprive the owner of the property, that seems to be unproblematic. So all are clearly present here. So likely to conclude Section 8, a robbery offence against Oliver. Okay, so any questions on those basic points as far as theft or robbery are concerned regarding Oliver? Okay, if we move on to the pub situation. So here, Oliver receives the additional £10, the excess payment. So what would our definition of theft be here? I know we've already defined it, but just remind me. If you hadn't defined it already, how would you define it? Okay, yes, so this would be the dishonest appropriation of property belonging to another with the appropriate intention to permanently deprive. So here, if we look at the actus reus elements first, and so those would be appropriation property belonging to another. So appropriation of the property, so we see from the slide that this occurs when Oliver comes into possession of the overpaid money, the £10 cash. So if we were in the tutorial room, I would have my £10 cash, and I would be holding it, and that would be the appropriation part. So the assumption of a right of an owner. Remember Lord Roskill's statement that the assumption of any right of the owner is sufficient in Morris. Now other parts of Morris have been discredited by the case of Gomez, but Lord Roskill's statement that the assumption of any right of an owner is sufficient, that's good enough. The money can be property within the meaning of Section 4 of the Theft Act 1968, because Section 4 actually refers to property being money and property, real property and personal property, and etc., etc. So here the problem is not that money is property, but the question is whether it belongs to another, because cash is quite a sort of peculiar scenario. So it's a bit like, in the banking world, sort of bearer instruments, where these are documents entitling the holder to the right of ownership or title to the property just by being in possession of the bearer instrument. So with cash then, as long as you are the bearer and you are in possession of that property, then you can sort of hand it over to somebody else in 7-Eleven or whatever, and proper title to the property passes. Even if you've stolen that cash, you can still give the person in 7-Eleven a good title to the property. So it looks like as soon as Oliver is in possession of the cash, then that isn't title transferred to him, otherwise our sort of currency system wouldn't work. And it seems that, yeah, that's true, but there is a fix for this, and in the Theft Act we need to have a look at the issue of belonging to another, and in Section 5, which is the section that elaborates on the meaning of belonging to another, Section 5.4 states that where the property has been received by another's mistake, and of course remember it's the barman who's made the mistake, then the defendant is under a legal civil duty to make restoration. So and actually the sort of the original owner who makes mistaken transfer, if you like, retains an equitable interest in the property. So but by applying Section 5 subsection 4 to this quite specific type of situation, this is like a sticking plaster to solve the problem. The property will be deemed or presumed to still belong to the owner. So this would be the barman, or more likely the employer of the barman, if the barman is acting as agent. So there is one specific case to really cite here that illustrates this point. So in Attorney General's Reference Number 1 of 1983, there was a woman police officer, and she was normally paid by direct debit straight into her bank account from the local police authority. And on one occasion, she was given a significant overpayment, and she knew about the overpayment, but she didn't do anything about it. She didn't actually spend the money. So here, ultimately, it was held that the credit balance that remained in her, the credit balance in her bank account remained the property belonging to her employer. So the property would be deemed to belong to another, so they still retained an interest in the property. So Attorney General's reference number 3 of 1990, sorry, number 1 of 1983, yeah, is the case to apply on that point. So the property is still likely to belong to another, to the bar owner or the barman if it's his bar. And, you know, there'd be very few situations where there was no duty to make restoration. It would only be in cases of non-legally enforceable debts. Now, difficult to find an example, but at the end of the slide, I have given a rundown of the case of Gilkes, but do bear in mind that when Gilkes was decided, that wagering contracts or betting contracts were non-enforceable. But after the Gambling Act 2005, and we see this illustrated by Ivey and Genting Casinos, then gambling contracts are now legally enforceable in contract law. There's a provision in the Gambling Act 2005 that says this. And of course we see in Ivey that Phil Ivey was legitimately making a claim for his winnings. He wasn't successful, but he had the right to make that claim. Okay, so, and then we'll move on to the mens rea aspect. So there's appropriation of property belonging to another, but what about dishonesty? His only chance in escaping liability is to argue that he didn't honestly think that he should have to return, you know, this minor sum of money. Maybe it was inconvenient for him to do so. He'd have to fight through lots of people to get back to the bar to explain this situation. So when we're dealing with dishonesty, as we said before, we would look at section 21A, 21B, 21C. So I'm sorry, that should be A, B, and C in that slide. So honest belief in a claim of right. So no, he probably doesn't honestly believe that. Secondly, honest belief that he would have the other's consent if the other knew of the circumstances of the appropriation. So that might be possible argument. So paragraph B, paragraph C, not likely that the true owner cannot be found by taking reasonable steps. Well, he does know who the true owner is. So paragraph B, the only argument there, if that doesn't work, then the court will apply the sort of default common law test under Ivey and Genting Casinos. And what we have to make clear is that Ivey now modifies the previous long-standing test for dishonesty, which is called the Ghosh test. So we've already done Ivey and Genting Casinos. And so basically applying the law to the facts, would Oliver be able to persuade a jury that a reasonable and honest person may actually keep maybe small sums of money? So again, it's up to you how you decide this sub-conclusion. Okay, so any questions on that part, on the you know, the retaining of the excess sum of money, the change? Okay then, so we can move to Andy then offers Oliver the mobile phone. So this is just a mention point, and it really, I don't think it should be in the question, to be honest. So this is potentially, you know, the mobile phone is sold to offered to Andy for a gross undervalue. So the hint is that this should be handling stolen goods, and we don't know whether it is the phone is actually stolen or not. So if it is stolen, no problem, it can be handling stolen goods. But if it isn't, and that can't be proved by the prosecution, then the appropriate charge is attempting to handle stolen goods. But of course, attempting to handle stolen goods is charged contrary to Section 1.1 of the Criminal Attempts Act 1981. And this we will do in the last lecture. If with intent to commit an offence to which this section applies, a person does an act which is more than merely preparatory to the commission of the offence, he is guilty of attempting to commit the offence. In other words, trying to commit the offence. So the actus reus part is doing an act which is more than merely preparatory. So acts are split up into merely preparatory acts, and then the embarkation of the offence proper, if you like. So if we're in that sort of preparation stage, then it can be an attempted offence. Okay, and here the problematic issue is whether the defendant can attempt to commit an offence which is legally impossible to commit. So we would apply Shiv Puri and Section 1 subsection 2 of the Criminal Attempts Act. Now, in this actual problem, you're not going to be going into this detail, but we will need to know about attempts a bit later. So here I'll just mention Section 1 subsection 2. A person may be guilty to commit an offence to which this section applies, even though the facts are such that the commission of the offence is impossible. So what the case of Shiv Puri does is confirm that it is possible for a defendant to attempt to commit an offence which is legally impossible to commit, and by a literal interpretation of Section 1 subsection 2, then that seems to be the right approach. Okay, so I just said it doesn't appear to be in the scope of the question, so you would just mention those points in passing. Okay, so then if we can move on to the tram ride. So here there appears to be obtaining services dishonestly. Okay, and he's not actually obtaining the tram itself, the property, but it's the service that we're interested in. Unusually, this particular offence, obtaining services dishonestly, Section 11 of the Fraud Act 2006, that this is actually a result crime. It's not in the inchoate mode, the sort of conduct mode, incomplete mode of the other fraud offences. So here, obtaining services dishonestly should not be confused with obtaining services by deception. Obtaining services by deception was previously the law under Section 1 of the Theft Act 1978, but with the Fraud Act, any of those deception offences were abolished and abrogated. So here we need to look at this fairly new offence, obtaining services dishonestly. So here the section 11 reads that a person is guilty of an offence if he obtains services for himself, so in this case, obtaining this tram ride for himself, or another, but that's not a problem for the Oliver scenario, by a dishonest act. So it suggests a positive act, so we have to look to see what Oliver does or it doesn't do, that he boards the tram perhaps without paying. in breach of subsection 2, and he obtains services in breach of subsection 2 if they are made available on the basis that payment has been made. In other words, this provision is restricted in scope to economic payments, if you like. So made on the basis of that payment has been made, is being, or will be made for or in respect of them. And secondly, that he obtains them without any payment have been made for or in respect of them, or without payment having been made in full. So the service is provided on the basis that there will be some economic payment in return, and then that service is obtained without the proper payment having been made, either no payment at all or not in full, just part payment. So all bases are covered, plus paragraph C, which is the sort of mens rea part of it. He obtains the service and he knows that they are made on the basis of payment, or that they might be, and that he intends that the payment will not be made at all or will not be made in full. Okay, so that's the provision. So the act suggests a positive act, so boarding the tram without paying. Obtaining, the prosecution have to prove a causal link between the dishonest act and then, as a result, because this is a result crime, the service is obtained. So yeah, that's a possibility here. And the services are available on the basis of payment, and the payment is not made at all or not made in full. Okay, so here, yeah, the tram ride, clearly a service. Now, it's difficult to get an authority, but under the old obtaining services by deception, then the case law gave quite a wide sort of interpretation of what could constitute a service. So wide interpretation of services. So you could mention the case of Sophron U under the old law, which was, opening a bank account. The argument was that the bank account, opening the bank account is not normally charged for, but the court said in Sophron U, well, okay, the bank don't normally charge you for opening your bank account, but they're not doing it, for charitable purposes. They do expect some payment at some stage in the form of fees or overdraft charges or whatever. And then the mens rea, is he dishonest? So now we've got to look at the test in Ivey and Genting casinos, and then the knowledge about the services on the basis of payment, and then intention to not pay at all or not pay in full. So here, I think the only real argument is whether he could be argued to be dishonest, not regarded as dishonest, under Ivey and Genting casinos. Now, remember, before, when we were thinking about dishonesty, we were talking in terms of, let's think about section 2 first, 21A, 21B, 21C. We don't do that here because we're not dealing with theft. We're dealing with obtaining services dishonestly, and there's no equivalent of section 2 in this provision. So could Oliver argue that he should not be regarded as dishonest according to the test in Ivey and Genting casinos? So you decide what you think the jury would do in those circumstances, and whether you think he has any real argument to say that he wasn't dishonest. I think the argument is obviously very weak, but you could consider it. Now, what if the payment situation for the tram is not, you buy the ticket before you board, and we're not told in the question exactly what the payment system is, so I mean, in Manchester there is a tram system, and you have these raised platforms in the street, and there are ticket machines, and you get the ticket first and you board the tram. So then in that circumstance, yeah, there will be obtaining services dishonestly, I think, if he manages to get, I don't know, a tram ticket from the machine by doing something to the machine, manipulating the machine to give him the ticket, or he just boards without getting a ticket, perhaps. But if the payment system is the opposite, it's like Hong Kong trams where you pay on exit, then we might have a problem with obtaining services dishonestly, because that offence is a result crime. So, if he obtains the service before the dishonest act, then he won't be guilty. So there are these older cases of DPP and Ray and Collis Smith that suggested that of their old cases that were dealing with obtaining property by deception, that if there was no causal link, then it could not be a result crime. So in that circumstance, we'd have to look to see whether an alternative offence could be applicable. So if Oliver had evaded paying for the ticket by some form of dishonest action before he got on the service, then yes, we could consider Section 11. But if Oliver was due to pay on exiting the tram, then Section 11 wouldn't apply. So we would have to consider in the alternative making off without payment. So here, this is a specific offence introduced by Section 3 of the Theft Act 78. And here it was designed to cover those situations where the defendant might go onto the driver's car onto the petrol forecourt, fill up with petrol, and then drive off without paying. And other circumstances, in a restaurant, for example, order a meal and then, while the waiter's not looking, zip out without paying. So making off without payment, supposed to be a simple offence. It's got a few sort of stages, and it's fairly limited in scope. So various elements then provided by Section 3 of the Theft Act 1978. Now, this offence, Section 3 of the Theft Act 1978, was not abrogated or abolished by the Fraud Act 2006, because it was never ever a deception offence. So here it's goods supplied or service done. Well, clearly the tram ride is service done. Then there should be making off, departing from the spot where payment is required or expected, without having paid as required or expected, and then there needs to be dishonesty or intention to permanently deprive the owner of the property. So here we would have we would have the possibility of Section 3 of the Theft Act 1978 if payment is at the end of the tram ride. So we could look through the possibilities there. So you say whether you think he was dishonest if he left the tram without paying, and the system was that he should pay at the end of the tram ride. So that's like a secondary argument, because the facts of the question support more the evasion of liability is before he gets on the tram. So that would be a Section 11 obtaining services dishonestly scenario. Okay, the last sort of sub-scenario is where the groceries haven't been charged for but by the supermarket. So here we have theft of those supermarket items that were not paid for. So should Oliver be liable for that? So first of all, is there actus reus? So, is there an assumption of a right of an owner? For example, possession. Is he in possession of the groceries? Yes, he is. The groceries are property. Do they belong to another? Yes, they belong to the store. We might say, oh, well, the property might have passed, but that's arguable. And even if it did, then it's by mistake, so we can apply Section 5, subsection 4. However, there is a bit of a difference here because Oliver doesn't realise until after he's left the store that he hasn't been charged for certain for certain items. So here, at the time, there might be appropriation, but there aren't the other elements of theft. So appropriation of property belonging to someone else, but at that stage he's not dishonest. He doesn't intend to permanently deprive the owner of the property. But later he does become dishonest, etc., and the other elements are perhaps there. So we have to look into the possibility of there being a later appropriation of the grocery items. So this is applying Section 3, where, is there a so-called later appropriation of the grocery items when the defendant has come by those items honestly without stealing them in the first place. So, okay, there might be a later appropriation, but what about the other elements of, dishonesty, intention to permanently deprive the owner of the property? When Oliver realizes, shouldn't he have gone back to the store to offer to pay? If he doesn't, then maybe he might be deemed to have a dishonest intention, but he could try to argue Section 2.1a, 2.1b, 2.1c, for example, that he wasn't dishonest because he had an honest belief that the owner would have consented had they known of the circumstances of the appropriation. So just think about this example, that at Christmas, my mother would normally go to buy Christmas items from a department store in London, and the department store in London is like 150 miles away from her home. And so she would go to London on the train, spend the day shopping, buying all these Christmas things, and then return to her home railway station that evening. Suppose she was on the train going down to London. She got the Christmas list, 10 items. She goes to Fortnum and Mason's and she thinks she's buying the 10 items, but actually she's only paid for 8 items. There are 2 items have been given to her and she hasn't paid for them. So maybe my mother doesn't realize this until she's on the train going home in the evening, and she's like 100 miles away from London. So that might be an example of where, she would have an honest belief, well, surely they don't expect me to turn around and go back, she's 85, and go back to London to return these items when it's their mistake, and it's unreasonable to expect that. So that's the sort of argument under Section 2, Section 2.1b. In the absence of a successful argument under 2.1b, and it's looking like Oliver realizes fairly immediately after this incident happens, then the default common law test is the Ivey and Genting casinos test. Now, you have to put yourselves in the shoes of the jurors and say what you think is the answer. If you think that you look at the circumstances from the point of view of the defendant, Oliver, and then you ask yourselves, you know, whether whether this would be regarded as dishonest by the standards of ordinary decent people. So, would Oliver's conduct be regarded as dishonest by the standards of ordinary decent people in the context of his honest belief? And then, so you might consider he's guilty or not guilty. The actual answer doesn't matter. I'd probably say he was dishonest. But then there's one further point to make clear. Could Oliver be charged with Section 3, making off without payment, in relation to the the uncharged grocery items? So if we look at the sort of requirements for Section 3, just go back. So goods supplied, so grocery items, making off, well, he's made off from the spot where payment is required or expected without having paid as required or expected. But the only problem is, at the time, the spot, he wasn't dishonest and he didn't intend to permanently deprive the owner of it. So, that's it. This is a very simple offence and very sort of tight application. So Section 3, making off without payment, does not apply to that last factual scenario where Oliver, keeps the grocery items, but he might be liable for theft there. Okay, so any questions on all that? It's quite a lot there. Just let you know that there are a few extra slides at the end, and at the end of the tutorials I'll post the slides. Gilks to explain that case, and also there's quite a lot on Ivy and Genting casinos. So make sure you read the relevant extracts in the case of Herring, and I shall refer to these articles in the lecture about fraud and how it's working out 10 years on. Okay, so any questions? Okay, as I mentioned before, we will try to do another question on the 30th of January so that you will have had your background in theft and fraud, etc., and then you'll be able to apply it to a scenario. Hopefully it will make a bit more sense then. Okay, if there are no more questions, then I'll leave it there and stop sharing, and you can await Mr. Mason for equity and trusts. Thank you very much.
Okay, can everyone hear me all right? If you can someone just type into the chat box? Okay, good. Right. So we're on to tutorial number 3, secret trusts. As you may already be aware, secret trusts appears on the exam paper as a whole question. It's in part B. Remember, you have to do one from part A, one from part B, and the third question you can choose whichever part. This one comes into part B. Now, let's just have a quick recap of those self-test questions. The cases on the left-hand side of the screen here are all the cases that are relevant, I think, to the self-test questions, and basically these probably constitute most of, if not all of the cases. Really, you need to be the fundamental authorities you need to be aware of for answering a question on this topic. But anyway, question number 1, traditionally, why were secret trusts used to dispose of property? Well, we looked at this in the lecture. Remember, this is because it's a way of keeping your affairs private, because when you've got a will will become a public document eventually. Once probate has been granted, it becomes a public document, and it can be accessed by any member of the public if they pay a small fee to access it, but it becomes public record. So if you've got illegitimate children or a mistress and you don't want the general public to know about that, or you don't even want your own family members to know about it, the way to do it is by way of a secret trust. That's the way of doing it. And they're still used today. And if it's a fully secret trust, of course, you would never even know. So a member of your family could have left something on trust for someone and you would never even know. It would look simply like a testamentary gift to X, but actually, unbeknownst to you and everyone else, X is actually holding that property on trust for someone else. Which brings us to the next question, question number 2. What are the distinctions between a fully secret trust and a half-secret trust? The main distinctions, well, essentially, it's with regard to the communication and acceptance. I mean, all types of secret trusts require you to show an intention of the testator to create the secret trust, communication of that intention to the secret trustee, and acceptance by the secret trustee. Okay, those are the essential elements of both. But where they differ between fully secret trusts and half-secret trusts is that fully secret trusts and half-secret trusts have different timing requirements as to when that communication and acceptance must take place. Okay, there are different timing requirements. And another way of distinguishing between the two is that, well, let me ask you this question. How would you know if a half-secret trust has been created? How would you know? Can someone suggest how you would know if a half-secret trust is created? How could you tell? How would you know? You wouldn't know if a fully secret trust was created unless you were told. But how could you know? How would you be able to tell if a half-secret trust has been created? Remember, it appears on the face of the will. The existence of that trust appears on the face of the will. The terms are not there. It doesn't say who the secret beneficiary is, but it's clear that the person who has been given this property in the will, the primary donee, the secret is holding this for someone else. So that primary donee is essentially the secret trustee, and they're holding it for a secondary donee, and that secondary donee is the secret beneficiary. Okay. So those are the essential differences between the two. Which brings us neatly then onto the next question. How do the communication and acceptance rules differ for these two types of secret trust? Okay, well, fully secret trusts. Okay, fully secret trusts. When must communication and acceptance take place for a fully secret trust? Can someone suggest? For a fully secret trust. Yes, any time before the testator's death, of course. It's a fully secret trust, so it can take place at any time before he dies. Half secret, and that the case authority for that is Wargrave and Tebbs. That's on the list there. You can see on the left-hand side, Wargrave and Tebbs. And for a half secret trust, the communication and acceptance must take place before or at the time of the execution of the will. Okay, and that the case authority for that is Blackwell and Blackwell. Okay, Blackwell and Blackwell. Now, when it comes to acceptance, when the secret trustee accepts basically agrees to be the secret trustee, he will normally expressly accept. But what if he says nothing? What if he says nothing? Can he accept by silence? If he says nothing, can he accept by silence? Can he accept by silence? Okay, what does anyone else think? Come on, other people to reply to this and get involved in the tutorial. It's just the same person answering the questions. Can he accept by silence? Actually, the answer is yes. It can. If he's silent, he remains silent. He can be held to have accepted by acquiescence, by saying nothing. And the case authority for that, anyone suggest that the case authority for that is? Case authority is Moss and Cooper. Moss and Cooper. See that on the left-hand side. Moss and Cooper. Okay, Moss and Cooper. So if you don't say anything, your silence can be deemed as acceptance through acquiescence. So if you don't want to be a secret trustee, make it clear. You need to be expressly clear that you do not want to be. Because if you remain silent, you may be regarded as having accepted. That's Moss and Cooper. Now, under what circumstances, question number 4, can communication be effected by a sealed envelope? Can it be effected by a sealed envelope? The terms, is that possible? So if I'm the secret trustee and if I'm the testator, let's say, I'm the testator and I want you to be the secret trustee, can I say to you, look, will you agree? You say yes, and I say, the terms, I'm going to write them down in this envelope, seal it. I do not want you to open the envelope until after I've died. Okay, and the terms are in there. Can I do that? Is that possible? Yes, it is. It is possible. Case authority? Yes, Re Boys and Re Keane, I would probably put as Re Keane is basically the Court of Appeal, just approving what was said in Re Boys. But yes, it can be. But yes, an important point there someone's just made. is that the secret trustee must agree to accept on those terms. He doesn't know what those terms are at that point when you hand him the envelope. He won't know the terms until when you actually died, after you've died. But he has to agree to hold them. He says to you, "Yes, okay, I will dispose of the property according to whatever's written in here. I don't know what it says now, but I won't open it until after you die. And I promise that I agree that I will dispose of the property in accordance with your wishes, as what's written down in here, this envelope." That's possible. So that's not actual communication. What do we call that in law? It's not actual communication. It's what? It's what? What's the proper legal term for this? It's not actual communication. It's what? There's a nice legalistic word for this. And this will have come up in other subjects that you've studied before. If it's not actual communication of the terms, it's what? Constructive communication. Well done. Yes, constructive. It's constructive communication. And that's valid according to Reed Keaton and Reed Boyes. But again, when we have a sealed envelope, remember the testator must actually hand it over to the secret trustee at the time. He can't say to him, "Okay, the terms are in the sealed envelope. I'll keep it in my own drawer, in my top drawer at home. When I die, come to my house and take it out." No, that's not good enough. He can't do that. He cannot do that. He has to actually give him the envelope. He has to give the secret trustee the envelope there and then. Okay, hand it over. Okay, so that is possible. Question number 5. Well, I won't go into this in any detail, but I've already mentioned it, gone through it in the lecture. But the fraud theory, remember, fraud theory, examiners like you to discuss these theories, show the examiner you understand the fraud theory and the Dehors the will theory. They like you to make reference to them in questions because it shows you've done some reading. But a fraud theory in a nutshell, essentially, equity will not permit a statute to be used as an instrument of fraud. That's one of the equitable maxims. Equity will not permit a statute to be used as an instrument of fraud. In this situation, in this context, equity will not allow the secret trustee to use the Wills Act, that statute, as an instrument of fraud. Equity will not allow the secret trustee to point to the testator's failure to comply with the various formalities in the Wills Act as a justification for denying the trust. Because that would essentially, it would be a fraud on the testator. More importantly, it would be a fraud on the intended beneficiary. The intended beneficiary. Okay, it would be a fraud on them to do that. So it will not allow the secret trustee, will not allow him to use the statute as an instrument of fraud. Will not allow him to rely on those formality requirements in the Wills Act as a way of denying this trust later on. And that's the fraud theory. Then we have the Dehors the will theory. Dehors the will, remember, that's the theory that says that secret trusts are not exceptions to the formality requirements in the Wills Act. Rather, secret trusts operate outside the will. They operate outside the will, therefore they fall outside of the scope of the Wills Act. According to the Dehors the will theory, although secret trusts are only constituted after the testator has died, because that's when the property vests in the secret trustee, although they're only constituted after the testator dies, they are not testamentary in nature. They are not testamentary trusts. Rather, according to the Dehors the will theory, the secret trusts are express inter vivos trusts. Why? Because they are created by the testator during his lifetime. And that's why the Wills Act does not apply, because they are inter vivos trusts, not testamentary trusts, according to the Dehors the will theory. because they are created during the testator's lifetime. It's only the issue of constitution, when they're only constituted after the testator has died, because that's when the property it vests in the secret trustee. Okay, so that's according to the Dehors de Will theory. Question number 6. Oh, actually, before we move on to that, question number 6, there is another theory I'll just mention to you in passing to show that if you want to show the examiner that you've done some reading around this, and you may already have read this in your textbook author, Hudson. Hudson has an alternative theory to the fraud theory and the Dehors de Will theory. He has an alternative theory. According to Hudson, he reckons that constructive trusts are what secret trusts are. He reckons that secret trusts are constructive trusts because they are imposed on the recipient of the testamentary gift, where that person knows in good conscience that he is required to hold the property on trust for someone else, for the secret beneficiary. And so he says, according to Hudson, these secret trusts fall within the test for constructive trusts, as per the Westdeutsche case, what Lord Brown Wilkinson was referring to. In other words, he's saying that a constructive trust is imposed on a person who has knowledge of some factor affecting his conscience in relation to the use of the property. Remember, equity works on conscience. And so this is why constructive trusts are imposed on a person who has knowledge of something which affects his conscience, knowledge of the way the property is to be disposed of. And therefore, the recipient of a testamentary gift, according to Hudson, a recipient of a agreed with the testator, he's entered into an arrangement with the testator property as a fiduciary, in a fiduciary capacity only, i.e. he will be a constructive trustee of that property from that moment onwards. From that moment when the legal title passes into his hands, after the testator dies. And so this is why Hudson says there's no need for formalities here, because the formalities are only relevant to express trusts, not constructive trusts. And we saw that, remember, in the lecture when we looked at when we consider Section 53(2) of the Law of Property Act. It specifically exempts this requirement for there's no need for in writing and signed as per Section 53(1)(b) of the Law of Property Act if you're dealing with resulting, implied, or constructive trusts. So this is why Hudson thinks that they are constructive trusts. This is what he argues. So essentially, when the courts impose secret trusts, according to Hudson, they are imposing the office of trustee on the recipient of the gift because it would be unconscionable for that person to retain an absolute interest in that property. Because the secret trustee is aware, he has knowledge. Equity operates on conscience. He's aware, he has knowledge that he was not intended to take beneficial title in the property, but rather to hold that property on trust for someone else. And this is why he says that it must be shown that there's been some a communication of the settler's intention and an acceptance by the secret trustee to act in that capacity. So that's an alternative theory by Hudson. Question number 6, are secret trusts required to fulfill formalities? Well, again, this leads on neatly then from them, because it's not clear. Okay, let's focus for a moment on fully secret trusts. It's not clear whether fully secret trusts, at least, are express trusts or constructive trusts. I mean, Hudson thinks all secret trusts are constructive trusts. But what we can say, based on the case of Ottaway and Norman, in Ottaway and Norman, the court left open the issue of whether a fully secret trust is an express trust or a constructive trust. And it's important to make this distinction because of the formalities, as I just mentioned, the formality requirements. We know that there are certain formalities, particularly with regard to land, the disposition of, where you're declaring a trust over land. Those formalities, in particular, Section 53(1)(b), the declaration of trust of land must be in manifested and proved in writing and signed. That Section 53(1)(b) does not apply to constructive trusts. That's made very clear in the following section, in Section 53(2). Okay, does not apply to constructive trusts. Now that's the position with regard to fully secret trusts. With regard to half-secret trusts, the case of Re Bailey, which is the second one on the list there, Re Bailey, in that case it was decided that half-secret trusts are express. They're express trusts in Bailey. That's what it was said in the Bailey case. Why? Because the trust is apparent on the face of the will. And they thought that Section 53(1)(b) of the Law of Property Act was required to be complied with. It must be complied with. And so in that case, the oral agreement between the testator and the intended secret trustee concerning land was unenforceable. But again, in Ottaway and Norman, when it comes to fully secret trusts, in Ottaway and Norman, the court upheld a fully secret trust of land with no reference to formalities whatsoever. So there is a bit of a grey area here. As I said, Hudson thinks that all secret trusts are constructive trusts. We have an authority in the case of Re Bailey saying that half-secret trusts are express trusts. But the case of Ottaway and Norman left open this idea. It was unclear whether they're express or constructive, based on the case and the judgment in Ottaway and Norman. So again, there's quite a bit of grey area here. It's not entirely clear. And question number 7, what is the position if the secret trustee or the secret beneficiary predeceases the testator, if they die before? Well, let's start off with the secret beneficiary. What can we say about this? Well, there is a case which examiners love to make reference to or structure a problem question in a way which requires you to make reference to. And this is the case of Re Gardner number 2. Now, Re Gardner number 2 is a bit of a strange case, and it's not supported by the law of trust generally or probate law. It is a controversial case, and it has been criticized. Let me give you, first of all, the general position. If the general position is if a secret beneficiary dies before the testator, then the trust will fail. The trust will fail, simply. It never goes to him. Because it never was constituted in his favor, because he died before the testator dies. It's only constituted after the testator dies. But he died before, so that means that's the end of story for him. Okay, so he or more importantly his relative, his heirs cannot benefit from it. That is the general position. The case authority for that is the Corbishley's case. Corbishley's on the list there. You see there, Re Corbishley's. That's the general position. However, there is an alternative authority, and that's the Re Gardner case. And according to Re Gardner, if the secret beneficiary dies before the testator, then his interest will not lapse. So that means then the secret beneficiary, even though he's died before the testator, his heirs are still entitled to that secret trust property. They're still entitled to it. Now again, this has been heavily criticised, this case. It's not been overruled, it's still technically good law, but I think we could put it into diplomatic terms by calling it an alternative authority. Okay? So the general position is in the Corbishley's case, that's the general position, but Reed Gardner is an alternative authority, and if you can point that out, examiners like to structure problem questions which involve you making that distinction and demonstrating that they are seem to be conflicting alternative authorities. But what about a secret trustee dying before the testator? Well, if a secret trustee dies before the testator, that depends on the type of trust we're dealing with. If we're dealing with a fully secret trust, then according to the case of Re Maddock, again is on the left-hand side of the screen there, the case of Re Maddock, then the legacy will lapse and the property remains in the testator's estate. Simple as that. Okay. However, if we're dealing with half-secret trusts, then assuming and provided that the terms of the secret trust can be ascertained, let's say they're written down in a letter somewhere, for example, as long as the terms can be ascertained, then the trust will remain valid because the court can appoint new trustees. Okay? Of course, the testator could appoint someone else. That's no problem. He could do that. But let's say he didn't. Let's say the testator died shortly afterwards, and so he never got round to doing it. But the court can appoint new trustees, provided that the terms of that secret trust can be ascertained somehow. They're written down in a letter. And the reason the court can do this is based on the equitable maxim that equity will not allow a trust to fail for want of a trustee. Equity will not allow a trust to fail for want of a trustee. And this is the Re-Armitage case, the one at the top of the list there. Re-Armitage. Okay. Now I did put onto Sol an excerpt, two paragraphs from the Lucien Freud case, 2014. I strongly recommend you have a read. It's very short, just one page there. I neatly put it into one page document. That is very useful because it's a very up-to-date, very recent, probably the most recent case, important case in this area. Secret trust, and it basically discusses when communication must take place and the consequences of failing. When the gift fails. It's very useful in paragraph 17 of that judgment. Do have a look. It's basically quoting from the leading practitioner texts in this area, and it sets it up very clearly. So do have a look at that document. It's very useful. Right, let's look at today's problem question. Now, as I have mentioned in the past, Manchester will release a suggested solution to the problem questions after each tutorial cycle. Okay, so if you don't get everything down, don't worry. You will get a suggested solution. And it is just a suggested solution. It's not a model answer, but they will circulate some suggested solutions to these. Okay, so don't worry about that. That will come around at the end of the tutorial cycle. But let's have a look anyway at how we might tackle it. Let's look at some issues here. And again, we've got clause A, B, C. Let's start off with clause A then. So this is Hassan's will. It's a valid will, so we don't need to discuss whether it's valid or not or anything like that, or whether they don't waste time with that. We've been told it's a valid will. There's no problem, no issue there. Let's start off with clause A. What type of trust is this, first of all? What type of secret trust is this? What is it? What type of secret trust is it? Yes, it's a half-secret trust. Okay, half-secret trust it seems. We know that because of its existence appears on the face of the will. Okay, we don't know it doesn't say the identity of the beneficiaries, the secret beneficiaries, but we know that the secret trust exists. Okay, from on the face of the will. So it seems to be a half secret trust over this £50,000, and Zahara is the secret trustee. Okay, secret trustee. What did I mention earlier? Is the secret trustee otherwise known as? Can anyone remember? A secret trustee is sometimes referred to as what? The terms are sometimes used interchangeably. It's useful to know this because when you're doing your reading, some of the judgments refer to this. The secret trustee is sometimes referred to as what? No. Well, yeah, okay, yeah, but okay, you're not wrong there. But I mean now, as opposed to the beneficiary. The beneficiary is given another. Okay, let me make this clear then, because no one's getting this. The secret trustee is sometimes referred to as the primary donee. Primary donee. Okay, because they're the one who receives it on, according to the will. So the primary donee. The secret beneficiary is sometimes referred to as the secondary donee. Okay, so just be aware of that in case you see it written. So primary donee, that's the secret trustee, the one who gets the property first, and the secondary donee is the secret beneficiary. Okay. So the terms are sometimes used interchangeably. Just be aware of that in case you're reading through a judgment, for example, and then you think, oh, what does this mean, primary donee? Primary donee, just a name for another name for the secret trustee, essentially. So then we go on to need to discuss the requirements for a valid half-secret trust. Well, the requirements are the same for all secret trusts, fully and half-secret trusts. We need to show intention, communication, and acceptance. Okay. But because we're dealing with a half-secret trust, we would quote the Blackwell and Blackwell as our authority. Okay, intention, communication, acceptance. Let's start off with intention. Has there been a clear intention to create a legally binding obligation here? Mandatory obligation, not a moral obligation, a mandatory obligation. Do we have an intention to create this secret trust, do you think? Yes or no? On the facts, do we have an intention? Is there evidence of an intention to create the secret trust? Yes or no? Yes, there is. And I can tell you with problem questions involving secret trust, that's not usually an issue. That's not really a big point. And it usually, almost always, will be clear. Okay, because they don't want to test that. They want to test you on the juicier stuff, which is communication and acceptance. Okay, so intention is okay. We've got intention. Tick. Okay, we've done that. Let's move on to communication then. Communication. And this is where you do need to demonstrate, and certainly you need to know the difference in the rules, depending on whether you're talking about a fully secret trust or a half secret trust. Okay. Now, Hassan seems to be creating a half secret trust, and so he has to communicate his intention to do, and the terms of this trust, secret trust to Zahara. At what point? When? When does he have to communicate this? What's the timing? What's the relevant timing here? Yes, before or at the time of the execution of the will. Good. Okay, that's the Blackwell and Blackwell. Okay. And likewise, she has to accept as well at that time as well. Okay, it's the Blackwell and Blackwell. Now, on the facts, the actual communication of the terms does not take place until after Hassan has died. because Zara opens the letter after Hassan has died, after his death. Is that a problem for us? She doesn't know the actual terms until after he's died. Is that a problem for us then? What do you think? No, that doesn't matter. Whether it's a term in the will, that doesn't matter. The fact is that the terms of this secret trust were not actually communicated to Zahara until after Hassan had died. Is that a problem for us, though? Okay, right. Yes, you're correct. The terms can be communicated by a sealed envelope. The case authority for that is... What case authority would we cite? We need to give an authority. If you want to get the top marks, you must give an authority. Just put in brackets, case name, Keen. Yes, Keen or Boys or both, either. Okay, Rekeen would be fine. Rekeen. Okay. So we can say that handing over the envelope with the terms, okay, and again, assuming that she knew that the terms were inside the envelope and she agreed to dispose of the property in accordance with those terms, then yes, we're okay. We would have then constructive communication. Okay. So the next issue then, with regard to this, like a sub-issue if you like, is was the envelope handed to Zahara before or at the time of the execution of the will, or after the execution of the will? Which one was it? When was the envelope, the sealed envelope, when was it handed to Zahara? Was it before or at the time of the execution of the will, or after? Before? Why do you say that? Where does it say that? No, we're talking about the facts now. We're applying the law to the facts. That's when Blackwell has authority for saying yes, it should come before or at the time of the execution of the will. But I'm asking you on these facts, when did Hassan give the envelope to Zahara? Well, no, he didn't hand it to her. She read it after he died. The answer is that we don't know. The facts are not clear on this point. And that seems deliberate by the examiner. Often you'll get problem questions where the facts are not entirely clear and you need more information. If it was real life, of course, you'd have a conference with the client to find out this information. But you haven't got that luxury in an exam. You have to work with what you've got. But sometimes some problem questions are deliberately, they leave something out because the examiner wants you to demonstrate that, that you understand that there's a key piece of information missing. And this is not a bad thing because it gives you an opportunity there to reason in the alternative. And this is where you can say that if the envelope was, assuming the envelope was handed by Hassan to Zahara before or at the time of the execution of the will, then it's okay. We're okay. But if he handed her the envelope after he executed the will, that's not okay. Okay, that means the trust would fail. And so the property would basically revert to the testator's estate. It would form part of his residuary estate. So whoever the residuary beneficiaries were under his will, those are the ones who would benefit from this property, from this £50,000. Okay. Okay. So we don't know when the envelope was actually given, handed over. Okay, we know that she read the terms after he died, and actually found them out then. But we know that constructive communication is okay according to E. Keene, but that constructive communication via the sealed envelope must take place before or at the time of the execution of the will. Okay, and that's a little unclear from the facts. We don't know that when the actual envelope was handed over. Okay, so it's something we can talk about. And if he handed over the envelope after the execution of the will, then the trust would fail. Then the next point is acceptance. Again, acceptance, of course, by Zahara must take place before or at the time of the execution of the will. Has she expressly accepted? Has she expressly accepted? No, she hasn't. But is that a problem for us? Is that a problem here? Zahara, I'm assuming, is a girl, but okay. She doesn't reject. Yeah. It can be accepted by silence. Yes, it can be. Case authority for that? Which authority would you put in brackets? Good. Yes. Moss and Cooper. Moss and Cooper. You can accept by acquiescence through basically saying nothing at all. Okay. Now, okay, let's recap then. We've got intention, we've got communication, we've got acceptance. Okay. Now, if all those three requirements are met, then it seems that we have a valid half-secret trust, and so Zahara will hold the property on trust for Ahmed. But hang on a minute. There's another potential problem here, isn't there? Look at the first sentence of the problem question, the very first sentence. And what do you learn from that? What could be a sticking point for us potentially here? Can anyone suggest? The very first sentence of the problem question. It seems that it might be presenting us with a problem. Yes. The will was witnessed by, well, not so important about Asif, but certainly Ahmed. He was a witness to this will. And what did I mention to you in the lectures? Remember, when it comes to Section 15 of the Wills Act, makes it very clear that a witness cannot be a beneficiary under a will, according to Section 15. So I think I gave you the example as well about, if you've got an old elderly great auntie who's a very rich elderly great auntie, and she asks you to come to the solicitor's office with her, and she wants you to witness the will that she's making, you best double check with her that she's not intending to leave you anything under the will, because if she does, then you won't be able to take it. If you're a witness, if you witness a will, you cannot be a beneficiary under it. So that seems to be a problem here for us, doesn't it? Or does it? Certainly under normal circumstances, it would be a problem. But is it a problem for us here? Is there a way out of this? Section 15 is very, very clear in its wording. A person who attests a will, who witnesses a will, cannot receive a benefit under it. That's crystal clear. Yes. Dehors the will. If we apply this theory, if we apply the dehors the will theory, then we're saying the secret trust is made outside of the will. Why? Because it was created inter vivos. It was created by Hassan during his lifetime. It wasn't constituted until after he died, true, but it was created during his lifetime, and therefore, according to the dehors the will theory, it is an express inter vivos trust. Therefore, it does not arise by virtue of the will. Therefore, it is not a testamentary trust. And so the Wills Act does not apply to it. It falls outside of the scope of the Wills Act. So it falls outside of the scope of Section 15. And this is the approach that was taken in a case called Re Young. I think I mentioned it in the lectures. Re Young. A case of Re Young. Now this supports the dehors the will theory. Okay, so if we apply that, then if we apply the Re Young case, that supports the dehors the will theory. So Section 15 would not be a problem for us. Okay, it would not be a problem for us. So if we apply Re Young, and assuming that the envelope, of course, was passed with the terms was passed to Zahara before or at the time of the execution of the will, then it seems that we have a valid half-secret trust, and therefore Zahara will have this equitable obligation to hold this £50,000 on trust for Ahmed. Okay. All right. What about B? What about clause B? What type of trust, secret trust, is this in clause B? Yes, a fully secret trust. And Frankie and Johnny are the secret trustees, and Sunil is the secret beneficiary. So again, go through the requirements to create a valid fully secret trust. These are in Ottaway and Norman. Remember, it's the same as half secret trust. You need to show intention, communication, and acceptance. But of course, remember the communication the communication acceptance must take place at any time before Hassan dies. Okay, it can be at any time before he dies. Okay, Ottaway and Norman. But there is an issue here that I need to draw to your attention, because sometimes the examiner may slip this in. There is a case called Re-Stead, and you need to be aware of this. Re-Stead. That's what this is getting at here in this problem question. I can see Re-Stead. This doesn't appear every year in in the problem questions. And if you look at the past papers, you'll see this I don't think it's appeared in the last few years, but it might get snuck in. So you need to be aware of this case, Restead, in case the examiner tries to catch you out. Now, this is you need to go and look at, go into your Hudson textbook, in your textbook, Hudson 9th edition, which is the latest one, and go and look at pages 279 to 280. Okay, it's a very, very short piece, and it's in section of the book, section 6.4.7. Okay. Now you can look at that after the tutorial. Go and look at this because this talks about the case of Restead. Because Hassan, although he's communicated the secret trust and the terms of the secret trust, he's communicated them to Frankie, he has not communicated them to Johnny. So the question then becomes, is Johnny bound by the trust? Is Johnny bound by the trust? Now, it seems Frankie and Johnny take this property as joint tenants because there's no words of severance, there's no suggestion of severance here, no words of severance, so they're taking the property as joint tenants. So this is where you need to explain and apply the rules from Restead. Okay. Frankie and Johnny are joint tenants on these facts, and communication to Frankie took place before the execution of the will. Therefore, according to Restead, both of them are bound. Now, why should that make a difference, whether it was before or at the time of the execution of the will, as opposed to after? Look at Restead. Go to that part of the book. Okay, it's a very, very small, piece of text there to look through. But be familiar with the case of Restead, and if you want the top marks, a critique. Hudson also provides a little critique of that case. Okay. It's all about whether, if it's you're talking about joint tenants here as opposed to tenants in common, joint tenants, and whether the communication to one of them, whether that occurred before or at the time of the execution of the will or after the will, because that then, according to Restead, seems to make a difference about whether they are both bound or only one of them's bound. Okay, so this is a cheeky little insert into this tutorial question, and so you should be aware, because this could be because this is a new tutorial question this year. So it's I'm wondering whether, and I don't know because I don't write the exam paper, I'm wondering whether the examiner will throw in a reference to this in the actual paper itself. I don't know. So go and have a look at that part of the textbook. It's just a very, very short piece there, and familiarize yourself with the rule around Restead. Okay, Restead. Okay. Clause C. Clause C. What type of secret trust is this? Does this seem to be? What does it seem to be? What's Hassan intending here? What type of secret trust is he intending? Fully secret trust. Nisha is supposed to be the secret trustee, and Sunil is supposed to be the secret beneficiary. Now, what's the problem here? What is the problem with this? What's the problem with regard to clause C? Think about communication. Communication. What's the problem with clause C? Well, sort of. So you're on the right lines there, but it's simpler than that. Yes, must be during their lifetime. This only came to light after he died, so this was not communicated to Nisha before his death. Okay, so this the trust would fail. This trust would fail. And so if you want some marks for this question, then you need to explain what would happen to the trust property, what would happen to the cottage. What would happen to the cottage then? What would happen to the cottage? The trust property. This trust fails. It's not valid. So what happens to the property? Yes, resulting trust. She'll be holding it on resulting trust for the estate, and it will pass to the who? Who will? Yes, the residuary estate. And who will benefit? Who will benefit from the residuary estate? The residuary beneficiaries. Okay, whoever's the residuary beneficiaries. Okay, I told you before when you're writing a will, you have to dispose of everything. You have to dispose of all of your property. But of course, you won't know when you write your will. You won't know about everything. You know, you can say, oh, "I leave my car to my brother, this to my so and so, and whoever. But you won't know all of your assets. What you can do is say that, and I leave my residuary estate to such and such. So that basically means anything left over. Anything left over after all the legacies have been distributed, all the all the other properties been disposed of, whatever's left, whatever that might be, you have to leave that to someone. That someone will benefit from that. Okay, and so this will just basically go to Hassan's residuary estate. Okay, as I said, after the tutorial cycle, Manchester will send round and circulate a suggested way of points to note sort of thing for that. So you can have a look at that. Right. Next, I'd like to look then at the exam practice question, which I asked you to have at least to read over the facts. I didn't require you to ask you to answer it. If you have, that's great, but at least familiarize yourself with the facts, and I'll just talk you through how you might answer this question. Okay. If you haven't read it, I'll just give you 1 minute now. If you haven't read this already, just familiarize yourself with those facts. Just have a quick read for 1 minute. Okay. Now, what type of secret trust are we dealing with, do you think? What type of secret trust? Yes, half secret trust, good. Okay, because again, the existence of the trust appears on the face of the will, but the identity of the beneficiary does not. We don't know who the beneficiary is. Now, again, we need to note the requirements for a valid secret half secret trust. intention, communication, acceptance, Blackwell and Blackwell. And remember, the emphasis should be on the communication rules. Intention's not usually an issue. They don't usually. That's something that you can that's dealt with in the three certainties question. Okay, when the intention. But for secret trust, intention is not usually an issue. You should mention it, of course, because it is a requirement. Mention it, but it's usually in a problem question that would not be an issue. Okay. What they're really testing is the communication and acceptance rules. Okay? So this is where you need to make the point that the communication and acceptance must occur before or at the time of the communication of the execution. Sorry, of the will. Before or at the time of the execution of the will. Okay. Also note again, Re Keane. It's perfectly okay, according to Re Keane, and for the terms of the trust to be included in a sealed envelope, but very importantly, the secret trustee must be aware that the envelope contains the details of the trust, and again, very importantly, the secret trustee must agree to hold the property on those terms. Okay, so they must be aware that the envelope contains, but they must agree to hold the property on those terms. Now, in this case, has Ollie agreed to hold the property on these terms? Has Ollie agreed that? Has Ollie agreed to do that? Well, yeah, silence, it could be, yes. We could say by silence. He hasn't expressly, not that we see from the facts anyway, but even if he hasn't done expressly, you're quite right, it can be by silence. The case authority, of course, is Moss and Cooper. So I mentioned that, Moss and Cooper, so it's acceptance by acquiescence. And again, another issue here, which was relevant to the previous problem question, so you can see how these themes get repeated, is the timing of the envelope. The timing of the envelope. Okay, the timing of the envelope. Now, it's not clear from the facts when the envelope was actually handed over to him. If it was after the execution of the will, then there's no valid will at all. And he can't take it absolutely, the property. He cannot say that, so it will be on resulting trust for the estate. Okay. But if it was before the execution of the will, or at the same time, that will be okay. That will be okay. That's sufficient. So we don't know, but again, we just highlight to the examiner that we understand the difference there and the fact that it's not clear from the facts. Okay, so now both Ollie and Tom were witnesses. Again, similar to the previous question, they're both witnesses here to the will. And again, we've got this clash between the Wills Act and the operation of secret trusts. In particular, we have Section 15 of the Wills Act, which makes very clear, crystal clear, that a person who witnesses a will cannot receive a benefit under it. And so Tom, according to Section 15, it seems, would not be entitled to take a benefit. However, we have the divorce the will theory. Based on that, and which is the case precedent that I mentioned earlier? What's the case precedent? Yes, Re Young. We follow Re Young, that supports the divorce the will theory, and so we could say that the Wills Act does not apply. Section 15 would not apply because this is not a testamentary trust arrangement. It's not a testamentary gift. It's not a testamentary trust arrangement because the trust was created during Joseph's lifetime. So it's inter vivos. It's inter vivos. So the Wills Act simply does not apply. It does not apply. follow the case of Ri Young. So by following Ri Young, Tom will receive his benefit outside of the terms of the will. So Section 15 does not apply. And again, if you want some bonus marks, you want some brownie points from the examiner, then you may want to provide a critical analysis of the Dehors de will theory. And if you go back to the lecture when I talked about the Dehors de will theory and the fraud theory, I did give you a bit of a critique of both of those theories. You could throw in a bit of that. The examiners love to see that. Okay, it shows that you know your stuff and you can critique it, the problems with those theories. Now, there is another problem here. Remember, according to the facts, Tom died before Joseph. Now, the general rule is that a beneficiary who dies before the constitution of a trust will not benefit under the trust. That's the general rule. What's the case authority for that? Somebody? What's the case authority? The general rule: if a beneficiary dies before the testator, so before the constitution of the secret trust, then they will not benefit from that trust. Yes, Corbishlis. That's the general position. So according to the general position, that secret trust would fail. Okay, so Tom's heirs, his own heirs would not be able to benefit from it. However, there is an alternative authority, the Ri Gardner case, which states that the gift is actually created at the time of communication and acceptance by the secret trustee. So it's inter vivos. So they're saying according to Ri Gardner, it's an inter vivos gift. And therefore, Tom's estate would receive it. His estate would receive it. Again, you can provide a critical analysis if you want some high marks of the Ri Gardner case. If you look in Hudson makes a critique of this, so you can look in your textbook. Hudson critiques the Gardner case. Okay. And what can we conclude then? Well, what will happen to the property then? What will happen to the property? Let's assume the court does not take Gardner and and takes the general approach and refuses to follow Gardner. What will happen to the property in that situation? So if the court refuses to follow Gardner, then Ollie, well, he cannot take it personally. He will hold this £10,000 on resulting trust for Joseph's estate, for the residuary estate. Okay, for the residuary estate. Okay, for the residuary estate. He'll hold it for the residuary estate. Okay, let me ask you just another question here, and this is not direct. I mean, it's sort of linked to this, but let me just give. This is one context in which it could arise. Imagine Tom and Joseph both died instantly, exactly the same time, and let's assume it's impossible, medically and scientifically impossible, to prove who died first. Let's say they both died instantly. Maybe, in actual fact, one of them died a split second earlier than the other. Okay, but it's medically and scientifically impossible to prove who died first. Now, this can be relevant in a legal context such as this, when it determines whether he died before the testator or not. Okay, this is just one context where it's relevant. Okay, but this is just a general point now. How does the law determine who died first? One of them had to have died first. But let's say it's medically impossible to tell which one died first. Scientifically impossible to determine who died first. They both died in a car crash, let's say. They both were killed in a car crash instantly, and it's impossible to tell which one died first, even if it was just by a split second. Impossible to tell. Yes, you've got it right. The elder one of the two is deemed to have died first. There has to be an answer to the question, because something very important could fall on the answer to the question, as in whether somebody, particularly in the law of succession, who receives what under a will, for example. Yes, if there's no other way possible, and it's medically, then it will be deemed that the elder one, the older person, died first. That will be the presumption there. Right, just before we finish off, I just want to go through a few very quick revision questions with you. Knowledge check questions, just to keep us on track. Okay, what are the requirements for creating a valid secret trust? Remember, evidence of intention, communication of that intention and the terms, and acceptance. Okay, and the terms. So it's intention, communication, and acceptance, the three requirements. Can a beneficiary be a witness of a will creating a secret trust? Yes. If the trust is created de hors the will, if you follow the de hors the will theory, then the beneficiary does not benefit from the will, but rather by the testator's inter vivos declaration of trust. That's the Re-Young case. So Section 15 of the Wills Act does not apply, because on this theory, on the de hors the will theory, the trust is created outside the will, and therefore outside the scope of the Wills Act. When must a fully secret trust be communicated? Any time before the testator's death. It's the Wargrave case, Wargrave and Thames. When must a half-secret trust be communicated? Before or at the time of the execution of the will. That's the Blackwell and Blackwell. What happens if a fully secret trust fails? Well, if a fully secret trust fails, the legatee could take absolutely. Okay, that becomes an outright gift. If it fails, if it fails, absolutely. What happens if a half-secret trust fails? Well, in that situation, the legatee will hold the property on resulting trust for the testator's estate. Okay, so he holds it on trust for those entitled to the residuary estate. Okay, an authority for the following propositions. The first one, communication can be made via an agent. I don't think that would come up, but just in case the examiner is being a bit cheeky and put something in about someone on behalf of the testator communicates, that is possible, and the authority for that is Moss and Cooper. Communication can be made by a sealed envelope. Yes, we know that. Read Keene. And acceptance can be implied from silence. Also, again, that's Moss and Cooper. Through acquiescence. What happens, next question, what happens if the sole secret trustee dies before the testator? Well, if it's a fully secret trust, the legacy will lapse. The property remains in the testator's estate. That's the Re-Maddock case. If it's a half-secret trust, though, the trust is still effective because of the maxim, equity will not allow a trust fail for want of a trustee. Okay, so if the secret trustee dies before the testator, the court can appoint trustees. Of course, the testator himself may do it. Can appoint someone, a secret trustee. But let's say that he dies shortly afterwards or doesn't get round to doing it. In that situation, the court can appoint someone. But so long as the terms are ascertainable, so maybe they're written down in a letter somewhere, for example, if they're written down somewhere. And finally, the last question. What happens if the secret beneficiary dies before the testator? Well, again, the general position is that the secret trust will fail. Why? Because the trust comes into effect via the will, which in turn comes into effect upon the settler's death, the testator's death. Therefore, if the beneficiary is no longer living at the time of the will coming into effect, i.e. when the secret trust is constituted, then there can be no trust in his favour. There can be no trust in his favour. That's the general position. That's the Corbishley's case. But there is an alternative authority which has received criticism. Alternative authority, Re Gardner. In that case, it was said that his estate, the secret beneficiary's estate, his own heirs would be able to benefit. But that has been heavily criticised, and you can see in your textbook, Hudson makes a critique of that. And as I said, the examiners like to throw this into question. So bear in mind that could come up where you'd be expected to note the general position in Corbishley's, but note there is this alternative authority in Re Gardner. Okay, does anyone have any questions? Does anyone have any questions? If not, we'll leave it there. The lecture is on Saturday, the lecture, and the next tutorial around is charitable trusts, the last one, tutorial for charitable trust. Okay, so I'll see you on Saturday. Have a good evening.